And this evening's broadcast of the North Idaho College Public Forum, a student production. Your moderator is North Idaho College political scientist Tony Stewart.
Good evening, ladies and gentlemen. On behalf of our regular panel, it is my great pleasure to welcome to our program this evening Mr. Sidney Smith. Mr. Smith comes to us from the field of law and will be discussing this subject with us tonight. May I give you his background? As to collegiate work, he did his undergraduate work at the University of Minnesota, and following that, he entered the law school at the University of Colorado and graduated from that institution. Then during World War II, he served in the Army in the artillery unit in Europe. From 1946 to 1969, he practiced law in the city of Coeur d'Alene. He is married, and also, in addition to all of that background, in 1970, he left our city to become a Deputy General Counsel in the General Services Administration of the United States government. He then returned to Idaho, where he served from January 1971 until June 1975 as the United States Attorney for the Federal District Court for the state of Idaho. In June 1975, he returned to Coeur d'Alene, where he has again entered private practice. Mr. Smith, it's a pleasure having you on our program.
Pleasure to be here.
Also this evening, back with us are two of our regular panel members. To my far left is Dr. Ken Wright, who serves as chairman of the Division of Physical Sciences at North Idaho College, teaching in the field of chemistry. Dr. Wright's degree, his PhD in chemistry, is from the University of Idaho. Welcome back.
Thanks, Tony.
Also back this evening is Mary Lou Reed, who lives in Coeur d'Alene and works in our area in environmental issues and also in the political arena. As to educational background, Mrs. Reed did her graduate work in theology at Columbia University in New York City. Welcome back.
Thank you, Tony.
We'll proceed to questions at once, and the first question this evening from Dr. Wright.
Mr. Smith, I think a number of the members of our listening audience might be interested in what your responsibilities were while you were the U.S. Attorney for the state of Idaho. Could you tell us what your duties consisted of?
Yes, the office is in Boise, and this is the main office for the state, and in addition to that, there are three additional offices that are not staffed, but which one is and was at that time in Coeur d'Alene, in the federal building here in the old post office. Another was at Moscow in a new federal building that was constructed about a year ago, and the third was in Pocatello. The duties and although we were primarily in Boise, we traveled to these other areas to hold court periodically as the court traveled to these same communities on a rather regular schedule. The purpose and our function as U.S. Attorney was to represent, really, the Justice Department out of Washington in the state of Idaho. We represented, and the U.S. Attorney does, serve as the chief legal officer for the Justice Department in Idaho, and handles both the criminal and the civil work for all of the agencies of government in the state of Idaho. As I say, both the criminal, with the criminal, we work with the FBI and the other enforcement agencies. The civil work, we bring all of the actions on behalf of the agencies of government, and for any work that needs to be done from the Department of Justice, this is performed out of the U.S. Attorney's Office also. Additionally, the U.S. Attorney is the one who is responsible for the defense of all of the actions that may be brought either by citizens groups in the test of any laws or any grievances they have against the federal government. And the U.S. Attorney is that legal officer who defends the action on behalf of the government.
You would normally be acting as the prosecutor then in all proceedings
Yes.
that the government was bringing.
Yeah, in that respect, yes. In all of the criminal actions that would be brought, I would have been the liken it to a prosecutor. Yes.
Did you cover all of these branch offices yourself, or did you have help?
No, we have in addition to 3 assistants, there are additional attorneys which we could call upon from the Justice Department, but primarily this was handled by commencing with 3, growing to 4. There are 4 assistants now in the office.
Mrs. Reed.
I have a question that may seem very simple, but I think it's very easy to confuse the state and federal functions. So in pushing us just a little step further, Mr. Smith, would you say what the difference between the U.S. Attorney for Idaho's position is and the State Attorney General? I think perhaps it might be helpful to really describe what the State Attorney General's office does.
The State Attorney General is the chief legal officer of the state, and in a sense has some, and I say some, supervisory direction over each of the 44 counties and the prosecuting attorneys, but that's merely directional, because in each county the prosecuting attorney is very independent, and in that he is elected by the people in their respective counties. So, but there is some direction that is given, and primarily the Attorney General is the chief legal officer for the governor, and with a staff assigns certain of his attorneys to the various agencies, and they guide these various agencies in interpreting the laws in their particular divisions.
And the functions then of the U.S. Attorney for Idaho are completely separate from those of the State Attorney General. I think this sometimes is not clear.
Right. It is very, there is, even though as enforcement officers, and may I say that as far as criminal prosecution, the Attorney General would have a very limited amount of that is the State Attorney General. All such prosecution criminally would be performed by the local prosecuting attorneys.
Again, for some more background and clarification, would you say a little bit about the differences between the state courts and the federal court? How do you get into one, and how do you stay out of the other, or vice versa?
Really, in Idaho, the reason one would be into the federal court would be because there was someone wanted to interpret a federal statute or the federal Constitution, if this were an issue. Otherwise, it is really voluntary on the part of the person, let's say a private litigant who wants to bring an action in the federal court. He would have to have 2 qualifications. First of all, the issue would have to be in excess of $10,000 in litigation, if it were, let's say, a damage action or arising out of, for instance, an automobile collision. But the other requirement would be that it would have to be a divergence of citizenship. That is, and this would be rather a normal situation where we're close to the Washington border, where frequently we may have people from Washington who are here. There would be an accident, and their actual residence would be over in Washington. Now, they would be privileged to bring the action here if they wanted to, because there was this difference in citizenship of 2 states. And I might explain that sometimes and very frequently it is because one is a corporation, and the corporation is not an Idaho corporation, but it may be a Delaware corporation or incorporated in some other state. Now, that's corporate body may bring an action in the federal court against an Idaho citizen or vice versa. But there would have to be this divergence of citizenship. Still, one other factor is that one would be in the federal court criminally because there is a violation of a federal statute, whether it would be a drug statute, a interstate transportation of a motor vehicle, something interstate that is occurring that would be in violation of a federal statute. And then one would be in the federal court. And additionally, if it were a federal enclave, and now this is, we have such in the Indian reservation down at Whirly, and we have another large area and around Pocatello and Blackfoot, where the Bannock Shoshone tribe is, and they have a large reservation. Now the violations there, this would be on a federal enclave in which there is the jurisdiction of the federal court for at least the Indian violations on those reservations. Additionally, one would be in federal court if it happened on the Mountain Home Air Force Base, and this would be a federal enclave because the land is all owned by the federal government. Additionally, in such parks as down in the southern part of the state, Craters of the Moon, and then we have a recent park down at Lewiston, the name of which slips me at the moment, but this would be the type of area that we'd have federal violations.
May I follow up with Mrs. Reed's questions? I have two or three on the same subject matter. In the Constitution of the United States, I think quite often we get confused, and as an expert, I'm sure you can clear this up for us. In the Bill of Rights, it talks about those common law cases, civil cases that fall under the federal courts, that if it's $20 or more, it can go into federal court. And you mentioned the fact that it had to be $10,000 or more, but is this a distinction between common law and statutory provision?
Well, most of our actions in the federal court, they are of, very seldom are we going to have that small amount, first of all, but there is a provision, not necessarily in the, say, in the common law, but for recovery against the government, and that is in the Court of Claims, and that's a separate court altogether, in which the problem in the past has been, over the years, one can't sue the king. And there was organized, quite a few years back at the time of the Civil War, the Court of Claims, in which there were many problems arising out of Civil War allocation and funds and contracts. And there was no relief being granted, and one would have to petition to the Congress. So the Congress set up what is called the Court of Claims, and this is really the redress where anyone wants to get their money back from the federal government for a breach of contract, that type of thing. And one would sue in the Court of Claims, but this court is not necessarily a creature of the Constitution at all. As a matter of fact, it's set up by the legislative branch in order to help the Congress, the federal Congress, to handle all this multitude of claims.
And Mr. Smith, with that court set up by the Congress, is there any limit on the amount of money involved before one can sue in that court of claims?
I think that the minimum is some approximately about $3,000. I'm not certain of the exact amount.
Okay. One more question before I return to the panel. If you would be kind enough to take a few minutes, would you also inform our viewing audience about the different processes in selecting judges in our federal courts? I'm speaking of the Federal District Court and the Court of Appeals and the U.S. Supreme Court versus the general ways that we select judges in our state courts, and also apply the same thing to the Office of Prosecution.
All right. May I say that, first of all, in the state courts, we do this by an election. And our district judges here in Kootenai County, we elect each 4 years for a 4-year term. And these are the district judges. A similar counterpart in the federal system is appointed by the president. And where our judges in Idaho are district judges, and I keep using that phrase, the district judges serve the term to which they've been elected. The federal judge is appointed for life. He is nominated usually by the party in power, that is a political party who is in the White House at that time. And they would control the appointment. Now, this is a normal situation. The individual would be appointed for life, and he will serve until he's 65 years of age, or longer if he desires. But he can retire at 65, and at that time, he will receive the same pay until he dies, so that he can quit working at 65, but many of them do not. And however, when they become 70, they must no longer be the chief judge. And let me digress for a moment and say that in the state of Idaho, which is called the District of Idaho, and let me digress just one step further. With the 50 states, there are 90 districts. Now, the more populous states have been divided. For instance, New York has 4 districts: Southern New York, Northern New York, Eastern New York, that sort of thing. California, as you've noticed in the papers recently, there are federal district courts involved in these cases that have been making the headlines, in the Hearst and the Fromm cases, in which one is in San Diego, one is in Los Angeles, one is in Sacramento, and another is in San Francisco. These are the heads of various districts, that as far as the locale. The states west of the Mississippi, strangely enough, they are all of one district except California and our neighboring state of Washington, where they have an eastern and western district. In all of the other states, there is just one district. So you have one district for Montana, for Utah, for Kansas, for example. Similarly, in each of those same districts, there is one U.S. attorney. So you have 90 U.S. attorneys and 90 federal judges. But the U.S. attorney is of the executive department, whereas the judges are of the other branch of the government, the judiciary branch. Now, getting back to the judges themselves, in Idaho, and let me say in the other states, depending upon the caseload, there are a number of judges. And also the staffs of the U.S. Attorney are increased. But in Idaho, we have 2 judges, Judge Anderson and Judge McNichols. Judge McNichols is the chief judge. Additionally, we have a 3rd judge, and this is a situation where we had a judge, Judge Taylor, who served as chief judge, and when he became 65, he could no longer be the chief judge, but if he desired to stay in office and perform as judge not only in Idaho, but in other districts that he might be called upon, Judge Taylor would continue to serve. Now, he's past 70, and he is still serving as a district judge, and he carries a full load, so that really we are entitled to 2 judges, but we have actually 3 working judges, and all of them travel about the state to these various places to hold court, as I've indicated. Now, this is the judge personnel, and each of them were nominated by the president on the recommendation of the senior United States senator at that time, and passed by the Judiciary Committee in the Senate, and upon that approval, with the recommendation to the Senate, they were confirmed. Now, the same procedure is followed with the U.S. Attorney. The appointment, the recommendation is usually made by the senior senator of the party in power in the White House, and at that time the Senate, the president would make the recommendation, and the Judiciary Committee would investigate, and then with the advice and consent of the Senate, why the U.S. Attorney is appointed. However, his appointment is for terms of 4 years at a time, or you fill out the last term of someone, your predecessor. Now, this is generally the difference locally of the 2 systems, and this takes care of the district judges. Additionally, there are magistrates, and we have in Kootenai County both lay magistrates and lawyer magistrates who do a great deal of work, serve a very vital function in the law process, and after a revision of the courts in 1969, there was established this system of magistrates, and they are elected. First of all, they were appointed by a panel comprised of judges, county commissioner, chairman, and mayors in this district in Idaho. In our district in Idaho, in Coeur d'Alene and the vicinity, includes, and this is the first district, this includes Benoit, Shoshone County, Bonner County, Kootenai County, and Boundary County. And in this county alone, or this district, I should say, we have 3 district judges, and they're Judge Tolles of Wallace, Judge Prather from Coeur d'Alene, and Judge Cogswell of Sand Point. And all of these individuals serve 4-year terms.
Thank you. So we are saying that in the federal courts, in both positions, it's an appointment by the president with the Senate acting, and in the case of most states, at least true in Idaho, that the voters are pretty much in control of deciding judges and prosecuting attorneys. Thank you. Dr. Wright.
Mr. Smith, your answers to the last question here raised another small question in my mind. It would seem that most federal judges and attorneys probably retire or resign because they prefer to return to private practice or something of this nature. Is there any mechanism for removing these men from office, short of dereliction of duty, which I assume there must be a mechanism for this, if they exhibit a certain degree of incompetence or are not satisfactory?
In the federal system, frankly, no. And this is one of the criticisms of the system in some circles. We are favored with excellent judges in Idaho. This is not always the case in other districts. The problem is, and I personally feel, and there are many who feel the same way, the permanency of their tenure and the fact that they have no one to account to, in a sense, and they're in there for life. They become very autocratic, and there is not a supervision a meaningful supervision, either by their own circuit. Now, for instance, in Idaho, the appellate court from Idaho is the Ninth Circuit, which sits in San Francisco, composed of the 15 judges who are appointed in a similar manner to our district judges. Now, they are the appellate court. They, in a sense, would supervise the appellate work and hear all the appeals from our local judges in Idaho. But they, too, do not have any corrective device or any pressure that they can really bring to these other judges whom they may think, and many probably would agree, and I'm not talking particularly about this circuit as I am thinking about some other circuits in the Midwest and the East where they do have some serious problems.
The same will hold true for the attorneys then? They are essentially have lifetime tenure?
The attorneys?
Yes, U.S. attorneys.
No, the U.S. attorneys have, their tenure is only for an appointed term of 4 years. And there is an unwritten and, just an unwritten understanding that if there were to be a change in the party in the White House, that the individual would tender his resignation, as one would tender it to at the change of office of the presidency, as did happen at the time that that President Nixon was replaced by President Ford. That at that time it was the accepted thing to do, and which all U.S. attorneys offered and through our executive office, and in a sense tendered our resignation. But immediately when this commenced, there were enough problems in government at that time. They needed some stability to the enforcement of all of the problems, and it was not really considered. It was a matter of saying, well, we don't want this. We're perfectly content to continue on in the way we have. So the tenure is actually for a period of 4 years, but often it will, many have been in now for 8 years or close on to 8 years now.
All right, now if I understand you right, then a man can easily be reappointed for another 4-year term,
oh, yes,
especially if the party in the White House stays in power.
And this is a very usual thing.
Mrs. Reed.
Can I just carry this one step further and ask, after 4.5 years with the Justice Department, would you recommend taking the Justice Department out of politics? Do you think this helps the Justice Department to be politically oriented or not? I think perhaps in the light of Watergate, there has been some sort of need to clarify who prosecutes the Executive Department and some of these conflicts that were highlighted that came with them.
It was rather interesting having experienced this whole time when the government was in the throes and the Justice Department being accused. And you recall there was appointed the counsel from Watergate, for Watergate and the prosecution, in which they set up within the Justice Department an entire section to handle this particular problem. I think U.S. attorneys throughout the country, and we've talked about this many times, are the influence of politics, perhaps in the larger centers. There may have been more, but by and large, most of the U.S. attorneys continued on performing their job as one would do in a professional manner in a large law office, and the the day-to-day problems of defending the government or bringing actions for the importation of drugs or importation of aliens, that sort of thing, I don't think ever missed a beat. It was at higher levels, and the direction from Mr. Mitchell, from Mr. Kleindienst, the day-to-day operation of the Justice Department went on without a falter as far as I could see.
Can I ask you, I can't resist, you perhaps got to know John Mitchell, and will you tell us a little bit more what sort of person you thought he was?
Well, I did come to know both Mr. Mitchell and Mr. Kleindienst. I wouldn't say that I became that close with Mr. Mitchell, but I thought him a very, rather a reserved individual, but one you could speak to, and always a very pleasant and friendly person. That although there were certain reservations about him, that and he continually, he had this pipe that he smoked quite a bit, so that's always a way of not hiding things, but disappearing behind the pipe.
Would you say you enjoyed your experiences with the Justice Department? Was this a broadening experience?
Yes, very much. I enjoyed it exceedingly. I've always enjoyed the practice here and the private practice, but something different, working for the government and a feeling of accomplishment, and to carry out the intentions at least from the Justice Department's interpretation of what the law meant and what was intended by these acts that the Congress passed.
I want to pursue a question that's before us now. It's being discussed by some members of the legal profession and certainly certain people in government. Justice Douglas of the U.S. Supreme Court recently came out against this proposal, and the former senator from North Carolina, Sam Ervin, also came out against it. And that is because the workload of the court has been increasing, or all the courts in our federal system, some have proposed a new appeals court just below the U.S. Supreme Court, are dividing the U.S. Supreme Court into divisions. And they're basing this on such statistics as I have before me. In 1951, I understand there were approximately 1,353 cases before the U.S. Supreme Court. In 1971, that had grown to 4,515. Also, our federal district courts between 1968 and 1972, the number of cases before those across the country were increasing by 10,000 a year. Is this a great problem, and is that the answer to create another court?
There are many in the legal profession who would not agree that another court is the answer. Many who feel that they want to appeal to the Supreme Court want the Supreme Court answer. And many feel that it's going to be just one more step to go through, and it's questionable whether they are going to be satisfied with this just additional step. Questionable on the part of many whether this will really relieve the Supreme Court of its workload. The one thing that should be borne in mind is that contrary to a common, say, rather common fallacy, the Supreme Court does not take every case that is presented to it. They weigh these cases to see, to consider not only the overall effect of to the country. If it is now we're talking about, say, the busing issue. Now this was one that would affect many school districts and had a broad impact. Now this would be one that the Supreme Court took on and decided. Now there may be constitutional issues that have arisen but yet they don't think they're of such magnitude that they can afford to take the time to hear these particular cases, so they, in a sense, what they call deny certiorari, and the case is not heard by the court, merely because they feel that there's other cases that are more important. So that every case that we have, one particular phase, and often the federal government is interested in this type of thing, is where the circuit, for instance, in San Francisco, the Ninth Circuit, would interpret a statute in one way, and then then perhaps short while after, or a year or so later, another district, say the Fifth Circuit, has another decision which may be the reverse of the one in the Ninth Circuit. So this is one that is desirable to go to the Supreme Court.
Thank you. We spent so much of our program on the structure, which I think is most informative, but I'd like to move to a question on one of the issues and then move back to the panel for their questions. Capital punishment is certainly an issue that's been with us since the founding of our Constitution and even before, and recently because of the U.S. Supreme Court's decision a few years ago that capital punishment was unconstitutional as written in the states, or applied, as how it was being applied in cases with a lack of uniformity. They declared those unconstitutional. I'm just giving this background for our viewing audience. And then the states have rewritten, many of them, their laws and have reinstated capital punishment. And the U.S. Supreme Court in Fowler versus North Carolina last spring was asked to review again the whole concept of capital punishment and stayed that decision until this fall, when they will be looking at it again.
Right.
My question is two-part. First, in your opinion, as someone who's been involved in the system, what do you think the Burger Court might do in that particular case? And secondly, what is your position on capital punishment?
If you perhaps the viewing audience and many will remember that the vote was very close, and when Justice Douglas was ill last year, it was considered that he may possibly be the swing vote, so that it's a very close decision. And Justice Douglas is serving and is expected to be serving on the bench when it convenes, and I believe on this coming Monday. My personal thought is, and my inclination is, that they will declare it constitutional. Perhaps, and this answers your second question, perhaps because I personally lean that way myself. I would like to see it restored. There is a threat, a deterrent, in my opinion, although there are others who would disagree, in the fact that there is a capital punishment and the possibility of death to one who breaks the law. And my own personal experience, I can remember defending one here in Coeur d'Alene, an individual who accused of murder out here at Wolf Lodge Bay, and the facts were very much against him, but the thing that he did not want was to stand the possibility of trial and the fact that he may have been sentenced to death. Now, he would take anything other than that. And I remember this particularly because I remember his mother. He was a young man, but his mother's hair turned white in the period of about 3 days' time. I didn't think that this would happen, but it did. So that I'm one of these things that I feel rather strongly about in having, and not only about the death penalty, but I feel this way about the law enforcement generally, that we are now in a pendulum swinging back toward more strict law enforcement and more forcible punishment, or rather than coddling many of the those who have been, I should say, that may not be a good choice of words, but many have felt that they should be treated differently, rehabilitated. I'm all for rehabilitation if this is in the scheme of things, but it's very difficult to do.
I would love to follow up on this. It's such a fascinating talk, but I must return to the panel. Dr. Wright.
Since Mary Lou Reed asked the question about what Mr. Smith thought of John Mitchell, I could barely resist the temptation to ask him what he thought of Martha Mitchell, but I think I'll leave that can of worms unopened on this program.
I'd be pleased to answer you. I think she's a very delightful and charming person, and I have noticed her on the television recently. It seemed to me that she's aged perceptibly, and but as far as a friendly, outgoing, warm person, we found that, and we lived in the same complex with them in Washington, and as my wife remarked, she's one of the few people that would go into the Safeway store and she would know all the clerks by name and be talking to them as she was checking out her groceries. So I thought that was always a nice thing to think about Ms. Mitchell.
That should be enlightening for a number of our viewers. I'd like to ask another opinion question here of Mr. Smith. You've had a good deal of experience both in private practice and as a U.S. Attorney for Idaho. I'm wondering how far down the road you think we've come as far as equality for all U.S. citizens go. I'm thinking now for the poor versus the rich, and minority groups versus the white Anglo-Saxon Protestant. Frequently stated that a rich white Anglo-Saxon Protestant will never go to prison or suffer a severe penalty in this country, and I'm wondering what's your opinion about equality?
I think the equality has grown, and if in my opinion, one of the reasons for the increasing caseload that we have, it has increased not only because of the population, and one great factor, and that's the drug problem. But in addition to that, the defense that we now give to the criminals. We do this here in Coeur d'Alene in our local court. We do this, and we do this by the public defender system, where anyone who is accused of a crime is, if he doesn't have the means to defend himself, no longer does he go without counsel, and this is provided for him. In the federal system, there are some areas where there is a public defender system, but in Idaho we do not have that. And, however, the judges are very careful to inquire of everyone who is arraigned before them as to whether or not they have funds in which to employ counsel, and they have a very elaborate questioning procedure at their first time before the court. And by and large, I would say that nearly most of them really do not have the funds on the surface and are all appointed counsel. And they are capable counsel. And the reason further that there's something about the system now that is militating toward even better counsel. And that is the fact and the problem that lawyers have like doctors. And that is a matter of malpractice. The lawyers who are appointed to defend these alleged criminals must perform and do their homework and prepare them and use every proper device in their defense and counsel them. Otherwise, they're going to be guilty of malpractice and or at least accused of that. And this is a very common experience that we've had in the federal court where an attorney has been appointed and they go through the trial, the individual is convicted, sent to prison, and the next thing we know, there will be petitions saying that he had improper counsel. So then the attorney has to defend himself, and the attorney is in a very, so that the attorney has to be very careful about his protection that he gives the individual. So that I would say that probably more than ever, we are trying more cases than we ever had before for this one reason, and I think that this is all for the good and for the protection of these individuals.
Who would bring the action against a public defender accused of malpractice?
Beg your pardon?
Whose responsibility would it be to bring action against
Well,
bring
the
malpractice?
action as you would normally be by the individual who is who has been sent to jail because he didn't have good counsel.
Mrs. Reed.
You mentioned that federal laws apply in Indian conclaves,
Right.
and on the reservation is really what you mean by enclave, is that right?
Right.
Would you describe the system of Indian justice? You still have tribal laws also that
Yes.
are applying, and then where do state laws apply, or do they at all on reservations?
On the reservation, the state laws apply by under our 10 major, the Major Crimes Act, by which the federal government adopts the laws of the state for such offenses as robbery, larceny, murder. The tribal laws are organized by the tribe themselves, and they have their own system, but there is no, this is really an internal structure patterned after and it only pertains to the Indians, has no control outside of their boundaries, really. And particularly, may I say that as far as Indians, that is a peculiar problem. And they, as wards of the government, the Congress has passed certain laws which define what the offenses are on the Indian reservation and how they should be enforced. If I may, I don't know where our time is right at the moment, but this may be a little rather interesting from a local standpoint, because about a little better than a year ago now, there were several young Indian men from Worley that with one of my assistants we tried in federal court for murder here, for burglary, murder, and larceny, in which the four young individuals, two of them were over 18, but this was in the death of and the beating of a white woman down at Worley, when the actual robbery consisted of, amongst other things, but primarily $1.30 and a purse. There were court-appointed counsel in that, and there were appeals, but they were charged with these several offenses. In order to, and in their protection, everybody had an attorney. When they went to, and they were convicted, but they were indicted under what was called the Felony murder doctrine, and that is that if there is a murder that is, if there is a felony in progress, that would be robbery or larceny, and there are several engaged in it, and then then a person is killed, everyone, or each of them, will be charged with murder. Now, that's the felony murder doctrine all over the country. In this particular case, it was appealed to the appellate court down in San Francisco, and in the last 2 weeks, a decision came back in which this, to support your query a few moments ago, Doctor, the protection that they received, and that the Circuit Court down there held that it was that they were deprived of due process. Now, the reason for it was that they were classified as Indians, and because they were Indians, they were forced to a different measure of proof than if it had been a white person who had done the same, committed the same offense on the reservation. Even though the federal law said that there will be the felony murder doctrine, in the state of Idaho, there is not such a felony murder doctrine. And one must prove that the individual deliberately and with premeditation intended and did kill this individual. The theory of the case was that, and the decision of the court was that it would be unfair for the Indians to be tried when, if it were a white person, they would have not been so, it wouldn't have been quite so easy to prove. We did have a felony murder doctrine until the legislature about 3 years ago revised and codified the laws and eliminated the felony murder doctrine. And this is the issue now, and it points up a good situation where the Ninth Circuit has made this decision, and by judicial determination have said that another branch of the Congress, or another branch of government, the Congress, has that they were wrong. And so this was an issue that in all likelihood will go to the United States Supreme Court, and because it affects all of the Indian lands and offenses of Indians on all of reservations in all of our western states, so that nearly all of the other states are also very interested. And this comes here arising out of the situation developed in Worley and tried in our courthouse here in Coeur d'Alene. And it's expected this will probably go to the Supreme Court.
And you feel that if this decision was upheld, it would have a great significance to all the laws pertaining to Indians throughout the country?
Yes, indeed.
Mr. Smith, I have a question that came out of the U.S. Supreme Court in June 1975, just before they ended that particular session and took the summer off. They, as I understand it, in June 1975, in a Supreme Court case, extended the Sherman Antitrust Act, or what they call price fixing, to attorneys, saying that through the American Bar Association and other organizations that there had been an understanding that there would be set fees for certain services in which no attorney would charge under that, and therefore that was illegal. Would you comment on this court decision? As from the viewpoint of, do you think it was a correct decision, and should that particular law have been extended as it was to attorneys?
I think I think that it was as far as an overall application of the law, it was as proper to apply it to the attorneys as to say realtors, doctors, any other practicing group, whether it be architects, and I believe, or whatever professional group. The district bar it was a rather common, say, common procedure, but in Idaho we didn't have it was not necessarily considered as a minimum fee basis, but it was what's called an advisory fee schedule. For that reason, but in many cases it became the minimum fee basis, and so that now that this has been in a sense upset, you find the application with, as I say, realtors, well, all of the other professions and accountants and so forth. They're bidding on the services on a, so there's not a flat fee.
Thank you, Dr. Wright.
Mr. Smith, the FBI and CIA have been in the news a great deal recently, and I always like to ask something about these two organizations if I get a chance, and you're a good man to ask.
All right.
The FBI is been under scrutiny lately for some of their practices, and of course the CIA it's been disclosed that they've been opening everybody's mail, including former President Nixon and even Senator Frank Church, the chairman of the investigating Senate committee. And many people would say that the FBI and CIA are operating outside the letter and intent of the Constitution and the law. What's your reaction to this? Do you think that the FBI and CIA have overstepped their bounds severely?
I frankly haven't enough knowledge about any more than, say, you have of, and what we hear on the television of some of the goings-on. It all depends on the, it seems to me, on the individual circumstances, and I do believe that many of us forget the critical times that we had in this country, and that in Idaho, I'll say that one did not feel it here, as one did when in Washington, when I think that there were many pressures on individuals who at that time felt in the interest of the country that they were, there are many things that they wouldn't have done normally, but were so fearful of the unrest, the Vietnam uprisings, the flood of people, the rioting in the streets, and when one sees the burning of the buildings in Washington and nothing but smoke and flames shooting up, and you wonder what's it all coming to, and it looked like like World War II all over again when the rioting was on. I was there and a part of it, and I have sympathy for many of them who may have been misguided into the pressures that caused them to do some of these things. Now, I don't agree with the whole philosophy, and when something was learned a few days ago of the
I'm sorry,
examining of mail. Yes,
Mr. Smith, I have to interrupt, but the clock has caught up with us.
Okay.
On behalf of the panel, I sincerely want to thank you for being with us tonight and sharing your views on all these questions. It's been most informative, and we had many others we'd like to have gone into: prison reform, the jury system, and the Berger and the Warren courts, and many other things. And so we'd like to have you back at some future date and discuss these other issues with you. Thank you very much.
Yeah, pleasure to be here. Enjoyed it.
I also thank our panel for, again, outstanding questions on these various subjects. Ladies and gentlemen, our guest this evening has been Mr. Sidney Smith, a former United States Attorney in the Federal District Court, serving the geographical area of Idaho. I want to invite you to be with us again next week when we'll be interviewing another personality of the Northwest of the United States. We'll be with you from 6 to 7 next week on Channel 7 out of Spokane. Good evening.
The North Idaho College Public Forum can be seen at this same time each week over this station. The preceding student production was brought to you by videotape recording.